No operating agreement? Congratulations. A stranger in a black robe now controls your business, and you don't even know it. Now, most entrepreneurs, they file an LLC and they think they're done. They skip the operating agreement, and that's a huge mistake because without one, you just handed control of your business over to a judge who really doesn't know you. They don't understand your business, and they honestly don't care about you. Now, I'm Karam. I'm the 20-year battle-tested lawyer. I've advised entrepreneurs on over $1 billion worth of deals, and I've actually litigated cases, partnership disputes, breach of contract. I've been in chancery court. I've been in civil court. You name it. I've seen how having weak operating agreements and weak partnership terms destroy your business, and it opens you up to personal liability. So today, I'm going to show you exactly how an operating agreement isn't optional and why without one, you're handing control of your business over to a judge. They'll make your decisions and they'll do whatever they want just so they can get to lunch. I've seen this movie before and you don't want to see it. And that's why this is one of the 101 deadly mistakes that gets entrepreneurs killed. So let's go. Here's the myth that most entrepreneurs believe. I filed my LLC. I'm a single member. It's just me. I don't need an operating agreement. Wrong. Or they think I'll just get one later when I grow, when I add partners, when things get complicated. But then it's probably too late because an operating agreement isn't paperwork for later. It's the foundation of your LLC. Now, without it, you don't have rules. You don't have structure. You don't have control legally. And when something goes wrong, and in business something always goes wrong, you're not going to like who steps in to make the decisions for you. So here's reason number one why you need an operating agreement. Now, without one, the state default rules take over, which means what? It means that every state has an LLC statute. That's basically the written law. And buried in that statute are the default rules on how to run your company. They govern how your LLC operates if you don't specify otherwise. Who gets the profits? The default rules decide. Who makes decisions? Default rules. What happens if a member dies? Default rules. What happens if you can't pay back a loan? Default rules. What happens if someone wants out? Default rules. And here's the problem. Those default rules were not written with your business in mind. They're generic. They're one size fits all, and they might be terrible to your specific situation. For example, some states say that profits have to be split equally regardless of who contributed what. Some states say any member can dissolve the LLC at any time. Now, some states have inheritance rules that could hand your business over to someone you never intended to get your business. So you built this business. You made the sacrifice. But without an operating agreement, the state's generic rules control everything, and they're decided by a judge. So when you end up in a dispute with a partner, with an ex-spouse, with anyone, a judge is going to open up that state statute, and they're going to apply those default rules however they see fit, and not how you intended, not what you agreed to verbally. The statute says what the judge has to do, and the judge has no interest in your business. They don't generally have a business sense, and frankly, they just want you and your mess out of their courtroom so it's easy for them. And that's reality. Trust me, they're just going to apply default rules and it becomes not your business anymore. That's the state's business. If this is hitting home to you, smash the like button because most entrepreneurs need to hear this sooner than later. So here's reason number two why this is such a big problem not to have an operating agreement. Not having an operating agreement is evidence of an alter ego. It's one of the factors the court will consider to hold you personally liable. Now, we talked about this in my video on how I break your LLC. Now, alter ego theory, that's the law of the land. That's how courts pierce your LLC and hold you personally liable. That means they can take away your home. So when opposing counsel wants to pierce your veil, and I've done that, they look for evidence that you didn't treat the LLC like a real separate business. That it was just you wearing a mask. And you know what's at the top of their checklist? What's so easy for the court to prove? Does this LLC have an operating agreement? If the answer is no, that's a red flag to the court. It signals that you didn't take formalities seriously. You didn't treat this like a real legal entity. You just filed some paperwork and you called yourself protected. You called yourself an LLC because not having an operating agreement is not only giving control of your decisions to a court, but it's also evidence that would support piercing your LLC and holding you personally liable for your business debt. One document. That can be the difference between your personal assets being protected or exposed. Now, courts look at multiple factors when deciding whether you've met the alter ego test. Commingling funds, undercapitalization, ignoring formalities. But having no operating agreement, That's one of the easiest factors for opposing counsel to prove, and it's black and white. It's really easy for a judge. Either you have one or you don't. Now, don't give them an easy win against you. Now, reason number 3 you need an operating agreement is that your operating agreement makes your actions as an LLC legally valid. This is the part most entrepreneurs never think about and they miss until it's way too late. So you want to add a member to your LLC. Your operating agreement should specify how that works. Without one, is that new member valid? What's their ownership percentage? How do they vote? What rights do they have? It's ambiguous. And ambiguity in law means disputes. Get away from there. Litigation, get away from there. A judge deciding your business, get away from there. You want to take on investors. What does it say in your operating agreement? And if you don't have one, you look amateur. You look like a risk. You don't look sophisticated. Investors will walk away. You want to sell your business one day, buyers do due diligence. They look at your corporate records. If there's no operating agreement, that's a huge red flag. It decreases your enterprise value. It creates uncertainty about what they're actually buying, and it shows that you're an amateur. Let's be honest. An operating agreement, it's legitimacy. It's proof that there is a real business with real rules and real structure, real resolutions. Every major decision you make as an LLC should be backed by your own operating agreement, adding members, removing members, taking distributions, making large purchases, bringing on investors, selling the business, making significant business decisions have to be documented. If you're learning something new, subscribe to the channel, smash the like button. I have a whole series on protecting your LLC coming up. Now let me address the single member LLC owners directly. I hear this all the time. It's just me. Why do I need an operating agreement? There's no one to agree with or disagree with, but here's why. First, it's called protection. Courts still look for formalities. They still want to see that you treated this LLC as a separate entity. And an operating agreement is evidence of that separation, plain and simple. Second, what if something happens to you? An operating agreement can specify what happens to the LLC if you're incapacitated or you pass away. Without one, your family might have to go through probate court just to figure out what to do with your business, and then the judge is applying the state default rules. You don't want that. And third, you might not be a single member entity forever. What if you want to add a partner or an investor? What if you get married and your spouse wants equity? Having an operating agreement already in place makes those transitions clean, simple, and legal. Now, fourth, banks and vendors sometimes require it. Try opening a business bank account or signing a major contract without seeing that operating agreement. And if you don't have one, you look unprepared. You look like an amateur, especially if the other side's got a lawyer. I'm telling people to run away. Single member doesn't mean no rules. It means you need rules that protect you specifically. Let me paint the picture of what happens when you end up in court without an operating agreement, even if it's a single member. Let's say you're in a dispute. Maybe it's with a former partner, maybe it's with a client, maybe it's with somebody who's just trying to pierce your LLC, a vendor, somebody who claims you didn't honor a claim you made. Now the judge looks at your LLC and they ask, where's your operating agreement? Now you don't have one. So the judge is going to apply state default rules. Like I told you, rules that you don't know, rules you didn't choose, rules that may not be in your favor, rules that were written for generic situations, not your specific business. It's not in your best interest. It's not advocacy on your behalf. And now there's ambiguity. So when there's any sort of ambiguity and there's no paperwork, the judge is just going to make the decision. You're going to stand there watching this stranger decide the future of your business when they have no clue about your business. They're going to decide who gets what, who owes what, how things get divided, all because you didn't have a document that would have taken you a couple hours to put together, or you could have paid a little bit of money and made the best investment in your life and hired a good, experienced attorney to take care of it for you. An operating agreement serves 3 critical functions you really have to understand. Number 1, it keeps the state out of your business, that person in the robe, from making your decisions, and you don't have to rely on state default rules. Number 2, it protects you from alter ego claims. It's evidence that you treated your LLC seriously. And 3, it makes your actions legally valid. Adding members, taking investments, selling the business, all of this is cleaner and more defensible with an operating agreement. This is business defense. That's what I call it. You don't want to wait until you're in court. You don't want to wait until a judge is deciding your future and you're flabbergasted. You build the foundation now, one document. That's all it takes to keep control over what you built. And the good news is I created a free free operating agreement checklist. It shows you the 10 provisions that every operating agreement must have. You can use it to audit your current agreement or see exactly what you're missing. It literally takes 2 minutes to review, and it's going to show you whether you're protected or whether there's a good chance a judge could be running your LLC based on rules you have no idea about. So the link's down in the description. Grab it now, and also make sure you get a free risk report and an action plan to get your business legally bulletproof. You can click below and you can answer some of my proprietary questions about your business, and we'll audit it for legal risk, all for free, and send you back an actual actionable plan to fix the issues before it becomes too late. Just click below on the risk report, and if you need an operating agreement that actually protects you, I've actually got an operating agreement system. It's an actual system built for single member and multi-member LLCs, and it comes with a couple mentorship sessions with me. Just click the link below, check it out, hit the subscribe button, and remember, defense wins championships. I'm Karam, the battle-tested lawyer. Stay legally bulletproof.